evening, everyone. This is Hengis Satanta Smoochworth. This video is a continuation of my last video, the shared topic being the Masterpiece Cakeshop case in this term's Supreme Court docket, also known as the gay cake case. The center of this case is a Christian baker who refused to make a wedding cake for a gay couple in contravention of a Colorado anti-discrimination law. The case has brought in almost 100 amicus briefs, or friend of the court briefs. The record is 148 for a case that also centered around homosexual marriage, Obergefell versus Hodges. The case with a high number of amicus briefs doesn't necessarily betoken legal complexity. Instead, the number is more of an indicator of the political importance of the case. The case is somewhat simple. There have been hundreds of First Amendment cases, specifically cases that focus on the exercise and speech clauses of the First Amendment, and many of them festoon the footnotes of the briefs in this case. Judging from the arguments of the parties in this case, the court, in my humble opinion, will have to address at least 3 of these former cases. I'll address them in their chronological order. The first is Wooley versus Maynard from 1977. That case centered around the motto of arguably the greatest state in the Union, New Hampshire. The motto is beyond dispute the greatest of all the states, that is, live free or die. And since the late 60s, every state license plate must have that same motto emblazoned on it. Obscuring the motto was illegal. A Jehovah's Witness objected to the motto on political and religious grounds and covered that part of his license plate. Although the fine was only $25, the man's conviction brought him all the way to the Supreme Court. There the objector won 6 justices to 3. New Hampshire nor any other state can compel an individual to use his property for, quote, the state's ideological message, end quote. A contrary bumper sticker, as the dissent authored by Rehnquist argued, would not have overcome the fact that the state is compelling speech in contravention of the First Amendment. Summed up succinctly, the First Amendment includes, quote, the right of individuals to hold a point of view different from the majority and to refuse to foster an idea they find morally objectionable. The second case I believe the court will have to address in its opinion, whether it decides for or against the baker, is Hurley versus the Irish-American gay, lesbian, and bisexual group of Boston. Boston has celebrated St. Patrick's Day in one form or another since 1737. In 1994, gay, lesbian, and bisexual group of Boston, also unironically known as GLIB. Notice how the Irish-American part was not important enough to make it to the acronym. This organization wanted to have a gay section in the St. Paddy's Day March. The private organizers of the march refused to allow them to do so. The gay group sued under Massachusetts public discrimination law and won in state court, just like the couple in the gay cake case. The Supreme Court unanimously sided with the march organizers. First Amendment protections cover symbolic acts, like having a parade. If the state were to mandate that a parade include a certain group, that would be compelled speech and thus a violation of the First Amendment. The controversy surrounding homosexuals celebrating Irish heritage during the St. Patrick's Day parade is still ongoing. The third case the court will have to countenance in its decision about the gay cake case will be Rumsfeld versus the Forum for Academic and Institutional Rights, also known as FAIR. The federal government withholds some funding from schools if those schools do not allow military recruiters equal access to other recruiters on campus. This funding rule is known as the Solomon Amendment, and it is codified in Title 10 of the United States Code, Section 983, subsection B1. Many schools were upset about this because, among of course many other reasons, the military had the dreaded don't ask, don't tell policy back in the day, and this policy strongly discouraged the discussion of one's homosexuality in the military. This policy even mandated that under certain conditions, a gay soldier or officer who discussed his homosexuality could be removed from service by talking about his proclivities. The Forum for Academic and Institutional Rights, or FAIR, sued the federal government, arguing that the Solomon Amendment violates free speech protections that universities are owed. Justice Alito recused himself, but the Supreme Court otherwise unanimously disagreed. Although there is a seeming similarity with the Hurley case here in compelling an institution that is uninvited to be able to join in it is different, because hosting recruiters, according to the Supreme Court, is not expressive speech, nor does the Solomon Amendment require a school to, quote, accept members it does not desire, end quote. Recruiters do not become part of the school, in other words. Are these cases consistent? If so, which side do they support more, the dissenting baker or the gay couple in the state of Colorado? I would love to hear your thoughts below. Thanks again for watching. My name is Hengis Satanta Smoochword. If you enjoyed, please like, share, and subscribe.